If you are on an H-1B visa, planning to apply through the FY2027 lottery, or you are an employer sponsoring H-1B talent, this video is the single most important update you will watch all year, because the entire H-1B system has fundamentally changed, and if you don't understand these new rules, you could lose thousands of dollars or miss your entire filing window. Welcome back to the channel. Subscribe if you haven't already, because today we are breaking down exactly what changed, why it changed, and what you need to do right now to protect your case. Let's start with the biggest headline, the $100,000 H-1B fee. Since September 2025, the administration has imposed a $100,000 fee tied to certain new H-1B petitions, and this is not a minor filing cost. This is a fee larger than what most companies pay in total sponsorship costs combined. Here is the critical detail most people are getting wrong. This fee primarily affects new petitions involving consular processing, meaning H-1B beneficiaries who are outside the United States or who travel internationally while their petition is pending. According to updated USCIS guidance, many in U.S. filings such as extensions, amendments, and employer transfers may remain exempt from this fee, but consular processing cases are far more likely to trigger it. This means one simple decision, whether to travel internationally during a pending petition, could now cost you or your employer $100,000. So if you have any H-1B case pending right now, do not book that flight home until your attorney confirms exactly how your case will be classified. In December 2025, U.S. District Court Judge Beryl Howell ruled against the U.S. Chamber of Commerce and the Association of American Universities in their lawsuit challenging this fee, siding with the administration's justification for the policy. The plaintiffs have already filed an appeal, so this legal battle is far from over, and we will continue tracking every court development because the outcome of this appeal could determine whether this fee survives long-term. Now let's talk about the second major change, and this one affects literally every single H-1B registrant starting this year, the brand new weighted lottery selection process. On December 23, 2025, the Department of Homeland Security announced a final rule that completely restructures how H-1B registrations are selected, and this rule became effective on February 27, 2026, applying directly to the FY2027 cap season. Under the old system, every registration had an equal chance of being selected, regardless of salary. Under the new system, your chances of selection are now directly tied to the Department of Labor's 4 prevailing wage levels. If your offered position corresponds to a Level 4 salary, the highest wage tier, you now receive 4 separate chances in the selection pool. Level 3 gets you 3 chances, Level 2 gets you 2 chances, and Level 1, the entry-level wage tier, gets you only 1 single chance. Here is why this matters so much, especially if you are a recent graduate or an early career applicant. Past analysis shows that approximately 90% of H-1B applications filed on behalf of international students fall into Level 1 or Level 2 salary categories, simply because they lack extensive work experience. Under this new weighted system, that same pool of early career applicants is now competing with dramatically lower odds compared to experienced, highly paid professionals. And immigration attorneys across the country are already advising employers to reconsider how they structure job offers and wage levels before registering candidates. The American Immigration Lawyers Association has formally challenged this rule, arguing that the underlying statute does not authorize USCIS to weight selection based on qualitative salary factors. But DHS has firmly disagreed, stating they have full legal authority to implement this weighted process. So unless a court intervenes, this system is here to stay for the foreseeable future. Now let's walk through exactly how the FY2027 cap season timeline worked, because if you missed any of these dates, you need to know where things stand. Registration for the FY2027 cap opened on March 4, 2026, and closed on March 19, 2026. With employers paying a $215 registration fee for every beneficiary submitted. Selection results were released by March 31, 2026, and selected employers were then given a filing window from April 1 through June 30, 2026, to submit full H-1B petitions, with an intended employment start date of October 1st, 2026 or later. If your petition was selected, your window to file has technically already closed as of this recording. So if you are watching this and you were selected but haven't filed yet, contact your attorney immediately, because missing this window could cost you your entire spot for this fiscal year. There's also an important procedural update tied to this cap season. USCIS implemented a revised Form I-129 effective April 1, 2026, which now requires significantly more detailed disclosures about job roles, required qualifications, and wage-level justifications. Immigration attorneys are reporting that USCIS adjudicators are directly mapping petitioners' answers on this new form against the Department of Labor's prevailing wage framework, and inconsistencies between your stated job requirements and your certified wage level are now triggering requests for evidence at a much higher rate than before. In plain terms, this means vague or inflated job descriptions that might have passed adjudication in prior years could now get flagged, delayed, or denied. So accuracy and consistency across your entire petition package has never mattered more. On top of all of this, there is a proposed rule from the Department of Labor, published in March 2026, that would significantly raise the required prevailing wage for H-1B workers and other employment-based immigrants. This proposal calls for minimum salary increases ranging from 21% to 33%, depending on the worker's experience level, and the public comment period closed in late May 2026. The Department of Labor is expected to attempt finalizing this rule by the end of 2026 or early 2027, and if it goes into effect, it would represent one of the most significant cost increases to H-1B sponsorship in the program's history, potentially forcing smaller companies and startups to rethink whether sponsoring foreign talent remains financially viable at all. And if you're an international student on OPT, hoping to transition to H-1B status down the road, there's one more rule you need to watch closely. In August 2025, the Department of Homeland Security proposed replacing the current duration of status policy for international students with fixed admission periods, meaning students would no longer automatically maintain status for the length of their academic program, but would instead need government approval to extend their stay beyond a set limit. This proposed rule is expected to be finalized soon, and if implemented, it would make it significantly harder for students in longer programs, such as PhD candidates, to maintain lawful status without additional government approval steps. So here's what you need to do if any of this affects you. If you are currently holding a pending H-1B petition, avoid international travel until your attorney confirms your fee exposure under the $100,000 rule. If you are an employer planning next year's registration strategy, start structuring job offers and wage levels now, because the weighted lottery system means Level 1 and Level 2 positions face a steep competitive disadvantage going forward. If you are a recent graduate on OPT, speak with your school's International Student Office and an immigration attorney about how the proposed duration of status changes could affect your specific timeline. And if you are tracking the DOL wage rule, mark your calendar for updates expected later this year, because a finalized rule could reshape H-1B sponsorship costs for every employer in the country. This is exactly the kind of fast-moving, high-stakes immigration news we cover every single week on this channel. So if this video gave you clarity, hit that subscribe button, turn on notifications, drop your questions in the comments below, share this with anyone in your network currently navigating the H-1B process, and we'll see you in the next update.